Number 14, the people of the state of New York versus Michael Pena. Counsel?
Good afternoon, Your Honors. My name is Ephraim Savitt. I represent the appellant Michael Pena. Had my client murdered 3 people and been sentenced to the sentence that he got, 75 years to life, I'm sure I wouldn't be standing before this august court.
And Mr. Savitt, may I interrupt you for 1 second?
Please.
Would you care to reserve rebuttal time
Oh,
before
I'm
we
so
get into
sorry.
the argument?
Yes, if I may have 3 minutes of
Yes, you
rebuttal
may, of
time.
course.
Thank you.
Counsel, could you address the preservation argument?
Yes, Your Honor. First and foremost, under criminal procedure law 470.05, which is actually a very liberal standard for preservation.
Counsel, if it were as liberal as you say it was, then there would never be, that would swallow the whole preservation rule.
Well, Your Honor,
We would have to hear every case that came here, whether the issue were preserved or not.
well, the unconstitutionality of the sentence only arose after the sentence was pronounced, but even before the sentence was pronounced. And when the people were arguing for a maximum sentence of 75 years to life, I argued, because I was also his trial counsel, that my client, and this is on page 12 of the proceedings, part of my appendix, he deserves to be punished, but not punished as if he had committed multiple murders in a heinous way. He did not.
Well, you agree that he committed multiple crimes.
Yes, of course I agree.
And you don't dispute that consecutive sentences are appropriate.
Your Honor, I actually do dispute that consecutive sentences in this case are appropriate. I'm not saying
You're talking about in terms of the length. I mean, just as a matter of
statutory interpretation. Yes, of course, the statute it does not forbid consecutive sentences.
That's legal in this case. That's my question. Legal to impose consecutive sentences.
Under the statute, of course it is.
And do you dispute that 25 years to life for one of these crimes is a reasonable and not excessive sentence?
Well, Your Honor, given the fact that my client was sentenced to 3 times that,
well, I'm not talking about that. I'm asking about one sentence, 25 to life.
Your Honor,
for this.
Our position is that because he was a police officer and under the circumstances of the case, punishing him to a minimum, on the minimum side, to a sentence that is twice as long as the average rape sentence in New York State.
Your position, counsel, at sentencing was 10 years to life would have been more like it, right?
Well, that's what I argued before
Right.
the sentencing judge. And yes, it would have been more like it, but I understand that
What did the prosecutor ask for?
75 to life. Maximum punishment.
Yeah, 25 on each count.
25 on each count, so that for each touching, there's another dead body, basically. Essentially equating what, conceitedly, terrible crimes, but when there was a single victim who was not, thankfully, killed during the course of these crimes, or even beaten, and was able to return to her job within 2 weeks, I believe it was, after this incident, and didn't even require inpatient hospitalization.
Well, the trial
For
judge
each-
seemed to put a fair amount of weight on the fact that he was a police officer and that he did use his police weapon to coerce the victim into performing these pretty horrific acts.
Well, that's quite clear, and that's why he sentenced my client to 75 years to life. I'm arguing that under the 8th Amendment and under Article 1, Section 5 of our Constitution.
The problem is it seems the key, the heart of this case is whether or not the issue was preserved before we even address the 8th Amendment issues
Well,
in and of themselves. let me finish.
Oh, I'm so sorry.
So, as I understood the objection you gave in trial court, and you can correct me because you know it better than me, you said it was a draconian sentence, and then you made the comparison. But you never used the word unconstitutional, you never challenged it under the Eighth Amendment. Those issues were never specifically put before the court, because if they had been, then it would have required the court to do a particular analysis, like the Supreme Court's analysis as it's set out and look for the factors in Ewing versus California. And then we would have had a record in front of us to look at those issues, but that didn't take place here. So that's, I think, why we're focusing on the preservation issue.
Well, Your Honor, as a practical matter, even though the people asked for 75 to life, and even though this is a terrible case conceitedly, I was actually floored when consecutive sentences
That's
were
understandable, but
were-
how
were
about, has there been
imposed.
has been a post-trial motion, 44020, I think is the section, has that motion taken place? Was the sentence challenged that way?
No, it wasn't, but certainly there was at least enough of a protest to the position of the people that there should be maximum punishment in order
There were
to
a lot of-
preserve it.
Yeah, there was a lot of verbiage, counsel, as you pointed out, but the only word that you used was draconian. You didn't say it was cruel and unusual. You didn't say Eighth Amendment is,
I did not
mentioned.
say, conceitedly I did not, but, apart from the procedural, statutory grounds that I argue, and maybe I'm arguing on a slippery slope, this is in fact a constitutional challenge to the sentence that was ultimately imposed. And under the case law of this court, such a constitutional challenge does not have to be raised in the first place before the trial court.
in what case are you relying on for that?
People versus Morris, this court in 1984 held that an attack against the power of the court, the sentence as it did may be raised for the first time
Well,
on
you're
appeal.
talking about the power of the court. That's not the constitutional issue that you're raising now.
Well, Your Honor, the power of the court to sentence as it did is the constitutional
Yeah,
issue.
I think you're misunderstanding what the power of the court is there. If I'm right about that case, I thought it was a jurisdictional issue. It's different than the constitutional issue that you're seeking to raise.
But-
The thing about this case is that two things that strike me. Of course, it's an awful case. We all recognize that. But the other thing is that the legal issue in and of itself on the nature of the sentencing, if it does, it's a serious issue. It's not a frivolous issue. I don't think that, and you can't say that about everything we see. But it's very difficult for me to get around the preservation issue, and that's why we keep going back to it, I think.
Well, if I may, I keep going back to the language of 470.05. It doesn't have to be expressed, doesn't have to be implied, and it certainly was enough of an argument to the judge that a triple punishment would be unfair.
But if you had raised the Eighth Amendment argument and you've presented us with all kinds of statistics and comparisons and analysis, I think, isn't the point of raising the argument in a way that would be recognized as what it is, so that the trial court could have entertained these kinds of this evidence and these statistics and the arguments about proportionality and all of that, so that we would have a record to
Well,
review? I mean, can we do that now?
Well, Your Honor, in retrospect, obviously, it would have been better if I came in with all these statistics and mentioned Eighth Amendment, Article 1, Section 5. But as a practical matter, when a lawyer stands with his client before the court, the lawyer does not expect the judge to impose a sentence that is 6 times as long as the average sentence for rape in the United States. I understood that the judge was going to impose a tough sentence. The moment he said 25 years, I figured 25 years, okay, that's a murder sentence. 25, concurrent to, another pair of 25s, concurrent to another pair of 25s, is the consecutive part of it that I respectfully argue is unconstitutional under both the U.S. as well as the New York State constitutions, and that does go to the power of the court. How could a court have the power to impose an unconstitutional sentence?
Thank you, Mr. Savitt.
Thank you, Your Honor.
Counsel?
May it please the court, Joshua Haber for the people. Defendant's claim is jurisdictionally barred because it is unpreserved. Of course, now, defendant is claiming that his cumulative sentence is cruel and unusual under the state and federal constitution. As evidenced by Your Honor's questions, defendant never argued that his sentence was cruel and unusual before the sentencing court. Defendant never argued that his sentence was unconstitutional. Defendant never attempted to invoke the Bill of Rights of the federal constitution or the same rights that are in our state constitution.
Why doesn't the exception to the preservation rule for illegal or invalid sentences apply here?
Because this court made clear, actually, in People versus Ingram, which is controlling, that in order for a defendant to preserve a claim that his or her sentence is cruel and unusual, that defendant is required to preserve it in the court below. And of course, for the past 30 years, that has been the controlling law in this state. The appellate division in all 4 departments has repeatedly relied on that law, and with good reason, to find that other claims of cruel and unusual punishment raised for the first time in appeal are unpreserved. And ultimately, contrary to the defense argument here, all of the cases in which this court has found narrow windows through which preservation might be skirted, none of those apply here. For example, in People versus Fuller, which defendant attempts to rely on, the judge there delegated the sentencing power of the court to the Department of Probation. In other words, the question there was whether the entity, in that case, the Department of Probation, had the power in the first instance to sentence according to legislative prerogative.
Counsel, we've recognized the differences between that case and Ingram, didn't we, in Ingram?
Exactly, Your Honor. In Ingram itself, when the court announced that cruel and unusual punishment claims have to be preserved, there was a CF cite at the end of that sentence to Fuller and to Morse, on which my adversary now relies. Obviously, that CF cite meant that in this court's sound judgment, whatever rule of preservation might have applied in those cases that went to the question of whether the legislature in the first instance had empowered a judge to impose a certain sentence simply doesn't apply in the context of cruel and unusual punishment claims. And the reason for that is also just more fundamental. The legislature is in charge of empowering the judges in our state and the courts to impose sentences.
Counsel, if we agree with you, is the defendant without a remedy at all?
Yes, Your Honor. The defendant is here without a remedy. But of course,
doesn't he have an ineffective assistance of counsel claim?
No, I don't think so, Your Honor, for the simple reason that on the merits of
On a
this
440,
case...
no?
No, Your Honor.
Counsel is saying I had no clue, I didn't think about it, I didn't know what was going on?
No, Your Honor, because if you read the trial transcript, and with due respect to my adversary, he represented the defendant here with incredible competence and vigor below, and he did so as well at sentencing. And his surprise in the length of the sentence doesn't make him ineffective because, quite frankly, the sentence in this case, even regarded on the merits, is entirely constitutional.
But that is a question that the defendant could raise by a 440 motion. You're saying that you
Oh,
don't
I'm
think it has
sorry.
merit, but
Certainly. I don't think it's a meritorious argument. It's certainly an argument that the defendant could raise. Of course, the defendant could also attempt to bring habeas corpus petitions in federal court if he so chose, and then the federal courts would determine under federal constitutional precepts the constitutionality of this sentence.
Getting back to Judge Abdus-Salam's question regarding remedy, are there any executive remedies that can be sought?
Of course, Your Honor. The defendant could always get clemency by the governor. Admittedly, clemency happens on rare occasions, but as we've recently seen, defendants with extraordinarily long sentences, at times, based on their particular behavior in prison, circumstances change, and governors have that power to grant clemency.
Given
to
the crime
defendants.
here, pretty unlikely, don't you think?
I would concede that, yes, Your Honor. However, in other crimes that involved heinous acts of murder and even terrorism, governors have granted clemency in the past. So just because a crime is particularly heinous and troubling doesn't necessarily mean that the remedy of clemency is not available to defendant.
Did the people request consecutive?
Yes, Your Honor. Yes, Your Honor. The sentence here imposed by the court was the sentence that was recommended by the people here.
There's no surprise to counsel.
Correct, Your Honor. Correct, Your Honor. In fact, as counsel just said, he expected that the people would be recommending a sentence of 75 years to life. So in other words, going into the sentencing hearing, the defense had before it an expectation that there would be an argument here that a maximum sentence was permissible. And therefore, in that moment, it certainly was, could have been possible for the defense to raise a cruel and unusual punishment claim under either constitution. And just to get quickly to the merits of this case, albeit we can see this is a very long sentence, but to put defendant's cruel and unusual punishment claim in context, as far as the people know based on our research, there's not been a single prison sentence in the history of this state that has ever been declared cruel and unusual. In the history of the United States of America, there has only been one prison sentence for an adult defendant that was declared cruel and unusual, and that was in the case of Solemn v. Helm in 1983, where a low-level, nonviolent recidivist was sentenced to a life mandatory sentence without the possibility of parole for bouncing a $100 check. Here, of course, defendant's conduct is far different. He was an off-duty police officer who committed multiple heinous, violent acts of sexual assault. And I won't even get into the details of it. They're in the record for your honors to look at. But to say the least, the content of the defendant's conduct here was a far cry from bouncing a $100 check, which was the case in Solemn. And the defense can't point to another case throughout the country where a serious violent felon who committed multiple crimes, whether over the course of the same criminal transaction or on separate days, received what essentially amounts to a life sentence, and where that sentence was regarded as cruel and unusual. As the Supreme Court and this court have observed, applying the cruel and unusual punishment clause to sentences to prison sentences really can only come up in the exceedingly rare case. And given the facts of this case, given the egregiousness of the defendant's sentence, given the severity of the penal law provision under which defendant was convicted here, and the reasons for the penal law provision for predatory sexual assault, this is obviously not the exceedingly rare case. And in any event, as I started my argument, defendant's arguments to the contrary are simply unpreserved for this court's review under well-settled precedent. Unless your honors have any questions, we'll rest in our brief.
Thank you, Mr. Haber.
Thank you.
Mr. Savitt?
Thank you, Your Honor. First of all, of course, I appreciate my colleagues' endorsement of my skills. I almost feel that it's that I'm willing to agree with Your Honor that perhaps I was not entirely competent by not actually saying the words Eighth Amendment, but I did say, perhaps to my credit, perhaps to my shame, that he shouldn't be punished as if he committed triple murder. And it's true that I wasn't surprised, certainly at the time of the sentencing, that the people would ask for a maximum punishment, but I must tell you, I was shocked that the maximum punishment was actually imposed by the judge. The fact of the matter is, Your Honor, that if we're going to start looking at various cases, such as People versus Ingram, I mean, People versus Ingram was a relatively short opinion back in 1986, and at that time, I understand that there was an issue raised by the appellant about Eighth Amendment, but the fact of the matter is the case was really about a felony murder statute and whether or not there was any preservation to a challenge to the felony murder statute when the appellant in that case had been charged and convicted for invading a home and somebody gets a heart attack inside the home. The question was whether or not, he preserved any challenge to the felony murder statute, or that whether counsel asked for some sort of a...
Counsel, I agree with you. I thought Ingram was a very short opinion, so I got the records in Ingram to find out what was really going on, because I thought maybe counsel might have raised an Eighth Amendment challenge, but he didn't, because both sides, both the people and the defendant, agreed with asked the court to impose the minimum sentence. And he did not raise in the minimum, in the case of Ingram, who was, like your client, someone who had never committed a crime before, and had just tried to commit a burglary, and as a result of that, the person he committed the burglary against had a heart attack and died. Those are the facts of Ingram.
I understand that.
Right, and so that's the felony murder that you're talking about.
That's correct.
And both the defendant and the people thought that the minimum sentence was appropriate in that case, and the court imposed the minimum sentence. But the defendant then later thought, well, you know what, that's too much. That sentence is excessive and it's cruel and unusual, but he never raised that to the sentencing court.
I understand, but to your point, People versus Ingram involved a case where felony murder, in fact, was the law that fit the crime. A person doesn't have to intend to, as your honors know, to murder anybody or to kill anybody in the course of a burglary, but if somebody dies as a result of that, it's felony murder. Here it's different.
Are there any circumstances, counsel, where the gunpoint rape of an adult woman causing a life sentence would be unconstitutional?
Yes, Your Honor. I believe this is the case, and the
I'm sorry, I meant to say constitutional.
was constitutional. We would have to look at various factors that, frankly, Judge Carruthers did not, and we'd have to look at the defendant, whether or not he has any prior criminal history, whether or not this was, in fact, aberrant to the rest of his life.
The reason Judge Carruthers didn't look at those factors is because you didn't bring them to his attention. Isn't that true, counsel?
No, I did, Your Honor. I argue that my client, this is a first-time offender. It's a single episode. It's a single victim. It's a terrible crime, but don't punish him as if he killed 3 people. And that's where the Eighth Amendment and Article 1, Section 5 come into play.
Well, see, that requires an analysis of the harshness of the crime, or the harshness of the sentence and the seriousness of the crime, and then you have to compare crimes within jurisdictions and then similar sentences for similar crimes within jurisdictions. Usually that's the standard that Eighth Amendment cases are argued with under the Supreme Court standard.
Yes, Your Honor.
And that's where our lack of record becomes a problem. But anyway, I do understand your argument, but it's difficult, I think, to make it on this record.
Thank you, counsel.
Thank you very much, Your Honor.
You're welcome.